All right, I'm sitting here, I'm tapping my foot because have you ever done anything that you were so excited about what you do that you just can't wait to get started? Well, I'm watching the clock and I have still a couple of seconds. I think I'm going to go ahead and start anyway. If that's okay with everybody, let's go ahead and get started. I have, as usual, I have redone this class again. So if you've taken the class before, it's a whole different class today than it was last time I did it. I mean, it's getting to be where it's almost a 3-hour class. So anyway, let's go ahead and get started without much further ado. So we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke. There's my telephone number. There is my email address. Please feel free to reach out to me at any time. My whole career is based on your success. I want you to do well. I have not figured out how to monetize that yet, although I'm going to get there at some point. But for right now, I just want to know you're doing okay. So, send me an email. I'll bring that up a couple of times during our presentation. So today, I've been in real estate for well in excess of 40 years. I'm getting almost ready to make that a 50 plus years in the industry. I'm being told now that I am able to get free dues at the Department of Real Estate and all that kind of stuff because I've just been doing it too long. But I am a broker associate. I'm a broker associate here. I'm a broker associate on the East Coast. I'm about to become a broker associate in West Virginia. I've got people buying property there. And so, I encourage you to get your broker's license. And if you want help with that, I will help you do that. Okay. This, by the way, is being recorded just so everybody knows. Nobody can see you. Nobody can see your name, none of that stuff, but it is being recorded in case you want to watch it again. And as most of you know, after I'm done with the webinar and after they've done taking, deleting the expletive deleteds, remember that from the old Nixon era, then it goes live and I go ahead and I upload it onto my YouTube account where you can watch it again. So apparently that's been pretty popular. I do teach continuing education for attorneys. I log in on a regular basis because, most of my stuff there is also online. And it is continuing education, ABA approved MCLE credit. So in real property law, legal aspects of real estate, I've taught in the colleges for many years, kind of my specialty. On the right-hand side, you see I'm all about risk management. Okay, so enough about me. Let's move on. We're going to be talking about things today that are going to appear to be legal. I'm not a practicing attorney. I have no interest whatsoever. I think attorneys work way harder than we do, and I think we make more money than they do. I do a lot of trial work, mostly limited to testifying as an expert witness. Standard of care is my specialty. Did the real estate agent, did the broker do what they were supposed to be doing based on the code of ethics? Agents' duties of inspection and disclosure, for sure, at least in California. It's very different in other states, by the way. In other states, there's no obligation. In fact, I'll be talking about that later on this afternoon, about the differences between California and some of the other states where I am licensed. Market conditions in San Diego County. Conversation day not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. You're paying them to be there, and so you really should be taking their advice. You should let them know what's going on. My experience has always been that I worry more about the quiet agent than I do about the one that's visible and out there and doing stuff. So again, if you're quiet, I'm probably going to get that out of you. You're going to probably not be quiet. So our webinars are intended to be interactive. Please utilize the Q&A button to ask questions or offer input. I look forward to hearing from you. And by the way, it really helps me when you do that. I received a comment the other day that while a lot of people don't ask questions, probably because you're writing things down as fast as you can, but please feel free, ask questions as we go, because you help shape the direction. And again, I'm a practitioner like you are, so got a pretty good idea what you're seeing out in the streets. But if it's something different, I want to hear about it. Okay, so please feel free, just put it into the Q&A field, and I will take care of that. So this morning, and again, another beautiful day in San Diego. Diego. Hey, Gloria. Another beautiful day in San Diego, and we are going to talk about maintaining records and reducing risks. And as I said a few minutes ago, this is going to be very different than the class that I spoke about a month ago. I've added a whole bunch of new stuff. I've got the broker compliance model from the Department of Real Estate in here, all kinds of really good stuff. So we'll talk about that as we go. This afternoon, we're going to talk about all about disclosures. So we're going to take disclosures from the 30,000 foot level, looking down on, just the state of situation in California. And we'll do that from 2 to 4 p.m. And then on Tuesday, so on the 11th, next week, we'll be doing the TDS, the SPQ, the SPQA, and the AV. And my hat is off to our people at the education department. We have a department and we have a committee, but the department at SDAR, wonderful, wonderful people. They have added to that line, why do we need to use these things? And so I am going to kill these documents. I assure you it'll be a good time. I'm going to go through each one of them and show you where I'm seeing litigation, where I'm seeing trouble spots, and to show you how to do them so that you're more effective in your disclosures. So those are a big deal. The TDS really belongs to the seller, but we participate on page 3 with the Avid and things like that. We'll talk about that on Tuesday. Then Tuesday afternoon, we're going to talk about disclosures again, but this time we're going to drill into the statutory disclosures versus the contractual disclosures. And I'm going to give you a list of what the statutory disclosures are. Contractual disclosures, there's some that are common through our transaction, but then as you all know, somebody asked me yesterday, actually, can you create a checklist for what a real estate transaction looks like? And I'm going to tell you, CAR has tried that, and it's a difficult animal. I think you would agree with me. In every transaction that you do, you start off with the purchase agreement, but then it can take any number of turns, twists and turns, and make it a very exciting, dynamic process. And so again, check with your broker, because these are the kinds of things that you need to make sure that you are navigating them properly. And so, but a lot of different things can happen. So that being said, today, we're going to talk about member benefits again at SDAR. So thank you for joining us for our discussion of maintaining records and reducing risk. And at some point, I think I'm going to go ahead and have this class approved for DRE credit. It is not DRE approved for credit right now, but I'm thinking I'm just going to uptick this one. My RPA class got approved, so we'll be doing that hopefully coming up here in September. Plenty of time to get that out to the membership. That'll be a 5-hour, 5 continuing education credit class. And then after that, I'm waiting for a response regarding my buyer representation agreement, which will be a 2-hour class, but it'll be chock full of all kinds of good stuff. Okay, so just letting you know about that. And I think I'm going to probably send this one up. So this will be, another 90 to 120 days before it gets approved and sent back. So that being said, and your peace of mind, which is really what this is all about, right? We all kind of want to go home at night and not, I go home, actually I work at home. But you know what? I don't worry about how my day went. I don't worry about how the transaction went or how transactions are going, because I do everything by structure. So I do everything with, in terms of outlines and things like that. And part of my safety net, if it were, is my maintaining records. Now, I think for those of you that are newer in real estate, it's hard to understand the fact that 3 years from now, you could be getting that subpoena that says, somebody was unhappy in a real estate transaction, and now here you are, being asked to bring in your records, and a lot of times to defend yourself. And even this morning, I spent a lot of time reading legal articles on the subject, and so I want to share that information with you. So the structure of maintaining records and why it's key to your peace of mind. And so let's talk about the who. Who is going to require that you maintain your records, and then we'll talk about the what, the when, the where, and the why. So we're going to do the who, the what, the why, the when, the where, the how, And let's go ahead and get into the who, and I'm going to show you some really neat little ways to take care of your record keeping. Okay, so who do you interact with in your real estate transaction? If you think about that, that's usually where the harm is going to be. Remember that it's the buyer who sues. That's just a natural, just a natural course of events. It rarely is ever the seller who starts litigation. It's almost always the buyer. But whenever the buyer starts the litigation, then that means that we're going to probably be asked to come in, and rightfully so, that we come in certainly to defend our position in what was happening in the real estate transaction. So who do you interact with? So it's going to depend on your record keeping procedures. Who's going to be depending on your record keeping procedures in your real estate transaction? So let's start off. You are, right? So remember what I said a second ago? 3 years from now, actually, it's usually 2 years and 9 months or 2 years and 10 months, because in most cases, the statute of limitations is going to be 3 years to file a lawsuit. And I say in most cases only because there are some situations where it could be longer than that. And we're going to talk about that in a minute. But you are the one who really needs to be keeping records, and you are the one who's doing that to protect yourself. All right. So it's really important that you get really good at doing that. All right. And I'm going to show you, like I said earlier, I'm going to show you some easy ways to do this. So your assistant, your transaction coordinator, you need to have the records of everything that your TC did. Your assistant, your transaction coordinator, you need to have all those records. Again, you're probably in better shape if the TC is a company provided TC, company provided transaction coordinator, but their records need to be your records. And so we'll talk in a minute about how the broker's file needs to be much larger than your file. And so you have some protection if the TC is an employee of the broker. If they're not an employee of the broker, then you really need to be getting that file downloaded into your program for your own protection. We have a TC when we're a transaction management company, but sometimes we outsource to a TC who's really good, and she sends over a DVD after the transaction is closed. She sends them to the client, all that kind of stuff. You want your client to have that information. Today we're doing it more electronically than before, but it's probably a pretty good idea to do that. And everybody always loves to have a copy of their file. So again, your TC, your assistant, if you have an assistant, assistants are good things, right? Your transaction coordinator, maybe to a lesser extent, but you need to have a copy of what their file looks like. Again, you're not trying to protect them necessarily, but you might have to protect yourself from them. Okay, your broker, so your broker needs to have a file. And remember what I said earlier, and your broker does have a file, right? I mean, we have to believe that. I was management with the Rock people back 20 years ago, a long time ago. Gosh, yeah, 20 years ago. I was management, and I would be sitting in my office, and somebody would walk into the office and say, here's my file, I want to make sure I get paid. And I would look at the file, and it was just a couple pieces of paper. And I would say, well, okay, even back then, it was a bigger file than just a couple pieces of paper. And so I'd say, okay, when's it closing? And they say Friday. And I go, okay, that ain't going to happen. I mean, it's going to close Friday because that's what the parties want it to do. But, as far as we're concerned, we need to review the file, make sure we have a complete file. Okay, again, why? Because we're the broker, and we want to make sure that our file is complete, because we don't know where you're going to be in 3 years. You may decide to exit and go over to another company, in which case, as the broker, we have the obligation to defend. And so sometimes, unfortunately, we have to defend agents that are no longer with us. Again, that's why we want to make sure we have a complete file. Usually when I see the agent's file, it's a much larger file. They're giving us copies of things. Back in the day, we couldn't sue off a copy. You had to have the original. Today, copies are pretty much standard in the industry, unless it's an original notarized document or something like that. So as your broker, very, very important that we have a complete file. And again, you want the broker to have the file. You want the broker to have everything in the file, because at the end of the day, they're the one you're going to be counting on to defend you in the event that something goes wrong. All right. And so how about your lawyer? Well, hopefully you don't have, I remember calling Pete Selecki and who I just have a tremendous amount of respect for. He's our general counsel at SDAR now. He was our attorney at Prudential. And I remember when I opened up my own office and I called Pete and I said, hey, you know what? I'm thinking at some point, I'm really busy, right? And I need to be talking about in-house counsel. And he made a great comment, a compliment to me. He said, of all people who don't need in-house counsel, you probably don't need in-house counsel. Call me if you get into a situation. I was so honored by that comment, and I want you to be the same way. I want you to be thorough about what you do. And again, the record keeping is going to help you a long ways towards that. But if you've got to give things to your attorney, then that means you're probably already involved in litigation. And so, again, we try to stay out of that situation because there's really no money in it for us. For me, it's entertainment, but for most of us, there's just no money in it. Okay, so the Department of Real Estate requires, and we're going to go through some of the DRE's requirements here today, specifically some of the things that they're looking for when they are doing their review. This morning I was reading, I have the pleasure of getting to read some of the department's positions or decisions that they've come down with against real estate brokerages, and some of them are really not good at all. So again, remember, I would always say we love our broker. We want to take good care of our broker. So please be, very clear with your broker about what is going on in your life. But the Department of Real Estate very clearly wants to make sure that you have a complete file, make sure that you are maintaining your records. And we're going to talk today about things like text messages and stuff like that, and what they're looking for and how they look for them. Okay, so back in January of 15, there was a rule that came down that said that, well, I'll talk about it in a minute. We'll talk about that, okay, because it's going to be part of our outline today. California law requires you to maintain records. California law requires, and of course it says that you are required to maintain records for 3 years. For me, I think that's really mostly identified towards the broker, but I think it's also for you, okay? And so we'll talk about that requirement and how you can surpass the requirement and do those things, in addition to keep yourself safe. So what? So here's the key: anything material to a transaction. All right. And so I'm going to go through a list with you, but clearly anything signed by a party, right? So anything that anybody has signed. And when we break into the Zip Forms account, I'm going to show you some places in there to be looking for things. But when you break into that account, we're going to see that the material items, once something is signed in the Zip Forms program, it creates what's called a Zip Vault account. You can't go in and create Zip Vault on your own. It is created by the program once you've sent something out for electronic signature. And once it's retrieved back again, it saves it in as a Zip Vault product. And okay, we're going to talk about significance of that in a couple of minutes. So DRE requires, the Department of Real Estate, California Department of Real Estate requires that the sales associate, whether it's the salesperson, the broker, realtor, whatever, give it all to the broker within 72 hours of receipt. So that's the requirement by the Department of Real Estate. So anything that you collect, anything that you receive, you must give to your broker within 72 hours of receiving it. What? Anything material to a transaction. Your written agreement with your broker may require less time. So in Linda's brokerage, so the DRE says 72 hours. In Linda's brokerage, Linda has an agreement with her agents that says that 24 hours. She can't make it 56 or 76 hours, right? Can't be more than the DRE requirement, because the DRE sets the maximum limit on how long it takes you to get that stuff to the broker. But Linda can make it less time. And so in her office, she requires it within 24 hours. And we find it's very convenient for people. They can actually get it much faster that way, and it's top of mind or front of mind, as we say. And so Linda gets everything within a matter of moments in her office, which is probably what you want to be aspiring to. Okay. And so, and today with everything being electronic, it's not like you're giving up something that you want to keep a copy for yourself. Usually you're emailing it or putting it into a Dropbox or Google Drive, which is something else we'll talk about in a couple minutes. So again, as I said, anything signed by a party, clearly. Now, here's where I break rank with some of, I've had interesting conversations with brokers who have said, I've talked to the broker and I've said, what about those buyer representation agreements? And the broker's response to me will frequently be, did it result in a transaction? And so I'll say, okay, hypothetically, no, it did not. But it was signed by the buyer and it was signed by your agent. And so the broker will respond to me, and I hope the DRE is not listening to this, but the broker will respond to me and say, no, we don't require it. And I'm thinking, yeah, you do. You need to have it because it was signed by a party. Maybe there wasn't a transaction per se, not a closing of a transaction, an escrow, as we call them in California, but there was a signature by the party, and you do need to have a copy of that in your file. So anytime, whether it results in a transaction or not, and we're going to see the requirement in a minute when we look at what the DRE, when the timeline starts for purposes of the Department of Real Estate. So whether it resulted in a closing or not, you still need to maintain anything signed by a party, okay, for sure. All right. Again, easy to do if you have it in the if you have it in the Zip Forms program, which again creates a Zip Vault account whenever there's documents that are signed. So again, all disclosure statements. Okay. So now I've had some attorneys that I've spoken with who have said, you don't need to keep everything. You just need to keep all the disclosure statements. I kind of agree with that, but I still think you should keep everything, right? And why do they say that? And they say that because the obligation to disclose is paramount, okay, in our business, all right. And so whenever you get involved in litigation, it's probably going to be for something about failure to disclose, okay. And so there's that statutory or contractual. I've got it on the bottom of your page there. Statutory or contractual disclosure is going to be our topic for Tuesday, something we're going to get into fairly deeply. Okay, so let me take a look at my, whoops, got a lot of people. Hi, Stephanie, welcome back. Okay, so any correspondence related to the transaction for sure, all right? My experience is that the transaction coordinators will frequently keep better records than the agents will, which is really kind of scary, okay? Because we really need the agents to maintain their file. And if nothing else, a communication log should be there. What about Privacy Act? You know, certain things like the FERPTA, things like that, where I still see people having the seller fill out the social security number and things like that. I probably wouldn't have that in the file. Anytime you have that information, so what we see today, for example, pre-approval letters from the buyer, and the pre-approval letter contains, account numbers haven't been redacted, things like that. Those are really dangerous, but you can't unsee it, right? So once you've got it, I think it needs to get out of your hands and over to the broker as a matter of policy. Okay, so agents. So, the parties, any communication from the parties, any correspondence, and correspondence is going to be a big thing. It's not just going to be emails, which I prefer, but it could also be telephone calls. And so that correspondence log becomes very important. But anything going back and forth between the agents, I had a lawsuit. I've spoken about it briefly before, where the two agents were both on the same team within the same brokerage. One represented the seller, one represented the buyer. They had a great division of labor. The seller's agent only represented the seller, the buyer's agent. They never even talked to each other. And I met the two of them in the office up in LA area there. And I can see why they didn't talk to each other. Very strong personalities, but their entire file was all email back and forth. And so it was really a great case for me. I really enjoyed it because I can look at those emails, and it's a lot easier for me to see what's going on than it is, if somebody has a telephone call and then doesn't make a record of it. So transaction coordinators should really be writing down those records of telephone calls and things like that. And it doesn't have to be word for word. Please don't go there. It's just date, time, who it was with, manner of communication, and just roughly what was talked about. And you should be having that as well. So there's my transaction coordinators. We talked about that. Any communication you have, by the way, with the transaction coordinator needs to be also something that you keep a track of. I've had other transactions where I got called in because the transaction coordinator didn't work for either. The broker was double ending a transaction. The TC was brought in. to help with a transaction, ended up talking to the parties on both, which was really dangerous, because remember, TCs are not allowed to give legal advice, and if they're not agents in the transaction, clearly not working under the brokerage firm, then they need to make sure that they are documenting everything, and the agents should also be documenting everything. Again, remember in another class that I talked about, the Department of Real Estate requires, they think that when you're using a transaction coordinator who's not within your brokerage, that there could be undisclosed agency. So in other words, if the transaction coordinator has a real estate license and they're not working for the company that's doing the transaction, the DRE says very simply, agency disclosure signed by the agent, by the TC who has the real estate license under above the name of the brokerage that they are with, because we want to disclose the concept of agency, but that does not create an agency relationship. Everybody good with that? Okay, I didn't mean to go down that path, but we were there and I wanted to make sure we talked about that. So your broker manager, any communication you have with your broker, your manager, you need to be documenting that in your file, especially when you ask an important question that they come back and they give you an answer. I would be keeping that. I'm very aware of agents who have a regular practice of deleting emails. I wouldn't be doing that. Okay, keep those emails. All right. Affiliates, you're talking to the title representative, you're talking to the title officer. Even more importantly, again, most of the TOs that I speak with, they're all electronic. We're all talking in emails. I had an email from one last night that said, this is what the status of our file looks like. And then I sent them back a message right away and said, where's this, and this. And so again, email back and forth. And now, of course, they're coming up there. I remember I had an attorney who told me once, God created voicemail to give you time to respond and think of the answer. And I thought that was a great saying. And so now the TO is sitting there thinking, okay, what is it he's asking for? I'm pretty clear about what I'm asking for. And so now I'm waiting for that to come back in the file. So affiliates, very, very important. Your escrow officer, whoever it is, your home warranty rep says this is covered or this is not covered. Make sure it's in the file. Make sure your buyer's signing off on it. Okay. So all emails. All right, all emails. So what should you do with your emails? So you should get into the habit. There's a number of ways that I've been over the years that I've seen people for keeping their emails together. But one of the best ways is to have the property address in the subject column, okay, up in the email. So always have that in there. Escrow is always going to have the escrow number in there, but that property address or the client's name. Now I had a client who did 22 transactions with me, and so to put their name in there would have not helped me a whole bunch, because then I'd have to go through 22 different transactions. But you want to keep all your emails and you want to, and the easiest way to find them later, the way to sort them, because I want you to print them, save them as a PDF, and save those in the Zip Forms program. And I'm going to show you how to do that. But all of your emails, I had a broker that I got called in on a DRE audit. And the DRE just sends you this 2-page letter that says, send us all of this stuff. And of course, one of those things that they always ask for is all of your correspondence with the client. So the presentation I'm doing today, by the way, comes from experience and comes from what they're looking for. And they want all those emails. And this poor broker said, oh my God, I've got 5 different email accounts. And so how am I going to possibly do all that? And my response was, you need to get started now, because it's going to take you a while. And they gave that individual broker 2 weeks to come up with all of the information. And fortunately, they had emails. They had Yahoo and AOL and Gmail, several Gmail accounts, and all this free stuff, which is, and it creates some security issues, but, I don't even know, they might even had Prodigy, .net, an old Prodigy account, but all this stuff, and they were just corresponding back and forth with all these emails. So it was a couple of huge boxes full of emails ultimately, because the DRE wants to see that stuff in writing. They don't want, don't email it to them. They don't want that. In fact, I communicated with the department the other day on a class that I'm having approved, and they said, if it's going to be more than 14 pages, don't email it to us, send us hard copies. So I thought, wow, that's pretty interesting. It's just because they don't want to be printing all that stuff either. So, and I get that. So all of your emails, all of them, don't go hiding things. Conversation log, I mentioned that earlier. Are you writing down? Do you have a notepad? We used to keep them in our files when we had paper files, date, time, who the conversation was with, because assuming it's coming from you, okay, and what was the gist of the conversation, not word for word, and please be careful about recording conversations without other people's knowledge of them. I would just write down the hot spots, okay, and so we're going to talk about how powerful that can be in a minute. A written contemporaneous note. So a contemporaneous note means a note that occurred at or about the time of the incident. So at or about the time of the conversation. So buyer calls you up and says, I've decided not to do the physical inspection, and you're just writing stuff, especially when it's a telephone call, you want to be documenting that telephone call. And then again, I'm going to show you that confirming letter saying, hey, I told you to get a physical inspection, and you didn't do that. And I want it very clear that you're acting against my advice by not doing that. So any kind of a note that you write at or about the time, I'm hoping you're writing notes, right? But a written contemporaneous note at or about the time of the incident occurring, and there it is, written at or about the time the incident occurred. And I got that, by the way, that is in law school. You don't need to go to law school. That's the only thing I got out of there. That was an important thing. Okay. All right. So it's a pretty safe bet that if you are called into a lawsuit, you're probably the only one with those notes. And I see this time and time again, where plaintiff's counsel, they've got their case going, and the agent's got a really good file full of good notes. Again, careful what you write in your notes, but you've got a really good file full of notes, and yet the plaintiff themselves has nothing. And so you're going to win, right? You're not assured of winning, but it's a pretty safe bet that you're the only one that has notes. And so you need to be writing these things down. How about your text messages? So let's talk about that. You all know me, you've known me for a while. I have this real hard time with text messages, okay? So do not business text. I was involved in a lawsuit and all these lawsuits, by the way, are other people's, but attorney asked me for my text messages, and I said, I don't have any. And she says, you don't text messages? I said, I don't text messages with clients. You got all my emails. This is what that's going to look like. And again, the emails were between myself and the attorney for the defending broker, but I don't text message. Even the attorneys I work with don't text message, so we don't text message. So if you do, make sure you're keeping good notes. If you are business texting, all right, then be sure to have backup software that saves your text messages. And we're going to hit on a little bit of this a little bit later, but there's programs out there. I don't know. I've got SMS Backup Restore, which is a free software program, saves everything in my Google account. We have the enterprise version of Google. It saves all of those messages. I would definitely have backup software. I had a case where the agent's defense was, I don't have any of my text messages, and the attorney said, well, why not? And they said, well, because I changed carriers, thinking that was, all those text messages go away. No. So the attorney, of course, plaintiff's counsel then subpoenaed the text messages, and again, they're going to respond. They're going to get the text messages, and at that point, you don't have the ability to redact anything. Okay, so we'll talk about that. You definitely don't want plaintiff's counsel subpoenaing your records. Okay, you want to provide them if you have them. You want to provide them. Again, be truthful. Give them everything that you have. But if you don't have anything, they're going to go get them. All right, it's that simple. You won't be given an opportunity to redact those text message comments. And so when they subpoena them, they don't subpoena for that case. They get all of your text messages, and then they have people that they pay to go through those text messages and find the really good stuff. Everybody understand what I'm saying? So I probably wouldn't. I text message with family and friends. I don't text with clients, just not. And I tell people, I just told a broker this morning, don't include me in a group text, because that's that's why I don't give out my cell phone number. I don't need more text messages. Everybody good with that? And I get it. One of our brokers said to me, you need to get into the 90s, and I understand that. I don't want to get that part into the 90s. I want to, I'm pretty current on what technology looks like, and I'm pretty current on why not to use that technology. So again, I mentioned this a little bit earlier. January of 2015, there was a codification of the law that said that text messages, instant messages, and tweets are not included in documents that need to be kept unless they're designed to be retained or to create a permanent record. Okay. Again, maybe that record keeping that you're doing where you've got that backup software, maybe that becomes evidence, exhibit A against you at trial. So again, I would just probably steer clear of it, but I'm good with it. The Department of Real Estate has tried to collect these before, and that's kind of what went down here. There was an interesting case up in Temecula quite a few years back now, where the seller's agent sent a text message to two different buyer's agents saying, "You've got the deal." And both buyer's agents, the buyers relied on that and moved forward. And then, of course, there was litigation against the seller's agent. And so the Department of Real Estate doesn't get a copy of those text messages, but what they do is they wait for the outcome of the trial, and then they subpoena the court documents. So they're going to get them. Does this make sense? So they're very resourceful. So at least as of the 2015 holding, which is again almost 10 years now, they don't get the text messages. But trust me, they're going to get them one way or another. Okay, so again, texting, very dangerous. If you saw me, I was on a panel with Veronica Kilpatrick, the district manager for the Department of Real Estate. I just, anything Veronica says, I write everything down, right? Because everything she says is really good and very helpful. In my career as risk management, I was up there with Gov Hutchinson and Robert Sunderland, who happened to be an attorney for Crest Insurance, probably your company's insurance carrier, and we all agree, do not text message with clients. All right, so enough about texting. But again, if you're going to do it, make sure you have adequate records of them. So how does the DRE get yours? They subpoena the outcome of your court holding. Okay, confirming letters. Let's talk about confirming letters for a second. And so SDAR has a really good confirming letter, and I wanted to show you this because I like theirs probably better than most. Let me pull this up, confirming letter. Here it is. So this was put together by Jackie Oliver, who is one of the attorneys who is on the risk management committee at SDAR. And so she wrote this really just an eloquent dissertation on this. And again, folks, everything I've got here today, if you send me an email, I will send you this whole file. Okay, so you have this, but this is really good stuff. Now, I keep going back to the SDR website. I love SDR. I go back to the SDR website, try to find the where it is on their website, and I just can't find it. So I don't know. I'm not that bright. I get it, but here it is. I'll give this to you. Boundaries, easements, physical inspections, reports, disclosures, new facts, all this stuff. She just did a great job of writing this up. And I'm pleased that her office is in the same building mine is, but she's just really good. And so the gist of it, here it is. Now, this is if you're going to send a letter. Now, I tend to send emails, okay? Letters are, I'm not going to, there are certain things that you must send certified mail. But there are other things that don't require certified mail as long as you can prove delivery, okay? And so if I get somebody, whenever I send an email to somebody, I get a response. I want a response back from them. And so here's her letter. Really a great job, as I said earlier. We represent you, and down here, right here, the basics of your conversation, so we raised the issue of the inspection report, the missing roof tile, stuff like that. We discussed you following up with it. So mine always starts off with, thank you so much for your phone call. I just wanted to memorialize that conversation in writing because I really want to hone it down. Jackie's got a good way of writing that says, if you close this deal, it's against my advice kind of thing. And so, I do it, I come at it from a different angle where I want to try to keep the transaction going, but I want everybody to be very clear that they understand that I told you not to do that, or I told you to do that. In our household, Linda says, it's or I say, I don't touch that, it's hot, right? And so, again, if you work with children, then they're going to touch it. And so you just hope to God they don't get burnt so badly that it's a problem. But again, I'm send that out. My ending comment is going to be, if any of the above does not comport with your understanding of that conversation, please let me know immediately. Okay, and then you send it to them, and they send you back a message that says, I get it. I'm good with moving forward with my my decision. And so, okay, good. I got that in the file. Should I be printing that? And the answer is yeah. Should I be saving that email? Certainly I should. All right. So, and that's what this is all about. Okay. And so I'll put that into the body of my email for the most part. All right. Is everybody okay with that? Any questions about any of that so far? That's SDAR's confirming letter. Let's take a look at SDAR. I went years before they created one. No, I'm sorry, I don't have theirs. Shoot, I'll show it to you in a minute. But this is an example. I wrote up an example of what that confirming letter might look like. Here I wrote it to myself, copying Linda. Confirming our conversation. This is intended to confirm our conversation a few moments ago regarding my suggestion that you not write a non-contingent offer. If you choose to move forward, I want to be very clear that it is against my advice. If any of the above does not comport to your understanding, and there we go. Okay, so now you see, and there it is with all my happiness in there, very clearly my signature line. Okay, so let me show you. I'm going to take you to Happy Land over here, where I've got, where is it? Here we go. We're at the CAR website. I want to show you where this is in the Zip Forms product, because there's some really good stuff in here. And again, we're talking about maintaining records. And again, we're talking about the fact that disclosures are probably going to be, if you disclose, then why wouldn't you keep a copy of it? Because you want to be able to prove the fact that you made the disclosure. Okay, so that button's going. I'm going to need to now bring that page in for you. Where is it? Here it is. Okay, so here's my file. I'm going to go to Forms real quick. And then over here on the right-hand side, where it says California Association of Realtors, they don't, I'm pretty sure they don't have a confirming letter in here, but I'm going to show you where it is. Okay, so they don't have it right in there. When you go up here to California Association of Realtors and you come down to CAR sample letters, can you see this okay? Sample letters, and now look at all this. Confirmation of conversation, right? That's going to be one of the best ones in there. They have others in there as well, but let's just take a look at that really quick. Let me make it go full screen. Here's my confirmation of conversation. Notice to agent or broker, this is what we want this to look like. And then page 2 is the actual letter that you may be sending out of this program. Is everybody okay? I'm writing to confirm our earlier conversation. At that time, I suggested you do this. So I like this stuff. Again, this falls under the category of lots of really cool stuff that we all do, but that nobody knows where it is. Again, it's under CAR sample letters right up here. Everybody okay with that? I'm going to take us back to the California Association of Realtors, and right here where it says all, everybody see all, I'm going to go down here to disclosures. And so again, in this afternoon's class, we'll go pretty deep into the disclosures, the different ones that are the general, the bigger picture kind of thing. Remember too, that over here where it says form update for 6/23, this is all of the forms that were updated as of June the 27th. So right before the deadline, the 1st of July, new laws, new litigation, stuff like that. So here's a whole bunch of stuff that's in there. So I wanted you to see that only because I think it's very, very helpful to know that it is there. And if you forget where it is, you can always reach out to me and say, hey, where was that again? I'm more than happy to send all this to you. Again, I want you to know, if you look good, as I always say, if you look good, you make me look good. So I want you to look good. I really do. Okay. All right. So heading back to our PowerPoint here. Are there any questions so far about any of that? I usually use that as an opportunity to get a drink of water real quick. Okay, I give plenty of time for questions. You got to ask them. If you don't ask them, you don't get the answer. So, all right, we're good. Okay, so confirming letters, again, SDAR's version of it. Here's the website link. Now, I have clicked on that, but it doesn't take me where I wanted it to take me. So let's see what happens if I click on it. And it takes me to the home page for SDAR. I'll talk to them about that because I think that I think it's kind of important for us to have to know how to get to that. And again, great stuff. But SDAR, we'll create things and then we'll move on to something else. And so we'll forget where we put it. Or I don't think they forget where they put it. I just think that, for example, Smart Union, which is a program for doing tenant screening, is another great affiliation with SDAR. I couldn't find that either. I had to send one of our brokers to it, and they called it up and they sent them the link, and I thought that was great. So I'm going to talk to them about maybe putting this stuff someplace where people can find it, but I haven't been able to find it. But again, folks, I'm not that bright. So so that being said, let's go back to our PowerPoint. So CAR has their version, and I just showed you a second ago. What else needs to go into your file? Again, anything material to the transaction. So trust records, right? If your office requires them, right? So not all brokers are maintaining trust accounts anymore. If you're doing property management, then you pretty much have to. But all brokers are a lot of brokers are getting away from that trust account. Creates all kinds of issues. So just be aware of that. If your office requires them, make sure you provide them. CAR has discontinued the use of the forms. So for trust accounting forms. So if I go back in here and I click on all forms, and let's just go, actually, I think I can do it right in from in here. Nope, they even took them out of that part of the library. Okay, so you can see that. So I'm going to go back up to my all, and then I'm going to click on trust. And I just want to show you that here's my trust bank account record for each property. And as you can see from your screen, it says this form has been discontinued for each beneficiary. This form has been discontinued, and they refer you to the DRE website. So these forms are still available on the Department of Real Estate's website. Probably the best place for you to go if you're doing property management. Okay. All right. So that being said, flying back over to our presentation. So so again, go to dre.ca.gov and then just type in the search field in the upper right hand corner. It'll take you right there. Okay, deposit receipts, aka purchase contracts. So when in the old days, when you wrote an offer on a property, you would get a check from the client, from the buyer, and their signature would constitute the deposit receipt. So it used to be called the purchase agreement and receipt for deposit. But then we got away from that because we didn't want the agents taking the check anymore. So we changed a lot of rules. And so now the purchase agreement is really and joint escrow instructions, whereas before it was a deposit receipt. So, but do you have deposit receipts? If you've been collecting, checks from buyers, for EMDs, we call them, things like that, then you need to have a receipt for it. But those are things that if you've got it, you need to put it into the file. Canceled checks, if any, need to go into the file. Now, again, if your client is spending money on things, you don't necessarily have to have copies of their canceled checks. And be careful about emailing those back and forth because the bad guys can sometimes get their hands on the routing numbers, the bank account numbers, and stuff like that. So the why part of things, number one, professionalism. Number two, our clients. Number three, the Department of Real Estate. Again, why do we do all this? Because it just makes us look good, okay? And our clients are counting on it, all right? So it is within your standard of care. So that means that because the law requires it, code of ethics requires it, everything requires it, it is within your standard of care, code of ethics, okay? The broker has a legal duty to supervise, right? And the DRE requires it, and California law requires it, all right? So I'll speed up just a little bit here because I'm looking at my clock. So if you're going to be involved in litigation, it is going to be for failure to disclose. All right. So why not export to archive? Okay. And so I want to show you how to do that in just a second. So after you close the transaction, if you've done all the above, then why wouldn't you do this? Okay. So let's go ahead and take a look. I want to show you how to do this. And again, at any time, if you need help, please reach out to me. I'm happy to help you. I'm going to go back over here. I'm going to go, yeah, I don't want to save anything. I'm going to go to my transactions, and I have what we call a sample transaction. I'm going to go ahead and open it. Again, a live file. So here and in my sample transaction, I have essentially my seller template in here. And you'll notice I also have the buyer template in here as well. So it's a pretty massive file. So I've done my transactions. Down here, I have my conversation log. Notice this on the left-hand side. I've got my conversation log. I've got my disclosure folders. I've got my disclosures to send folders, things like that. Anything signed by everybody. And this was Linda's addition, and frankly, a pretty good one. So Linda decided that rather than having all these floating documents out there that people have signed, let's put them all, once they're done, everybody has signed them, we put them in one place. Okay, so that's what she does. She puts them in there. And again, this is her housekeeping for all of this. All right. So normally, if there was something that was saved, if there was an electronic signature that was sent out and it got signed by the client and it comes back into your program, that's when it creates the Zip Vault account. Very, very important, okay? Because you don't create a Zip Vault account yourself. Zip Vault account is the repository for everything signed by a principal. Remember, that's what we need to be saving. Anything signed by a principal, okay? So now I've got my account created. I'm going to go back up here to my folders. And I can see, we've got the writing an offer checklist. We've got all that stuff. We don't have anything signed. We even have the confirmation letter in there, right? So we have all that stuff that our clients do in the real estate transaction. So let's assume that this is a completed transaction. My transaction is over. It closed yesterday. I don't anticipate any need to get back into it again. So without losing the contents of the transaction, I go up here to this drop-down arrow. Can everybody see that drop-down? I click on that drop down arrow and I go over here to export to archive. Okay. I want to make sure everybody understood what I just did. This is important, folks. You asked me how to keep all those records. You go up here to the drop down, you click on export to archive, and then this is the folder this is the file that you get. Okay, and so at this point right now, everything is in there. All that stuff that we just had, some signed, some not. If it's signed, it's in there. And then I click on export. And then, of course, it says, this thing's 5 megabytes in size, which is considerably smaller than what it would be if people were signing things and that they were in here. And I click on my export button. Okay. All right. And then I let it go to work, and I can go back. I can go do other stuff. I don't have to worry about all that. It will show up in my email box, whatever email address you put into your Zip Forms program, as ready for download. Okay. And why do you do that? We do that because we want to export it out of this program. We want to save it to the hard drive. And I'm going to show you in a minute, or to the cloud, even better. Okay. Now Zip Forms, and it's interesting. I was reading an article by an attorney this morning, and they said, the Zip Forms product's got a great cloud-based repository for all this information, essentially unlimited, right? And I'm using Josh Sharfman's language, from probably 20 years ago, when he said it's pretty much unlimited. And I go, okay, well, that's cool. I like that. So you can save everything in here, but there's a couple of caveats. So remember, I have an opportunity or an obligation to maintain my records. If you leave stuff in here, once you stop touching the file, we are going to shred it. So 5 years from now, and rather than the 3 years, right? 5 years from now, they are going to shred it. And by the way, they can't get it back. So that's one of the reasons I tell you to download it. Now, again, you may just decide to only download your disclosures, things like that. But if you have been putting everything up in here, you have a pretty complete file. Is everybody okay with that? I told you I would show you a shortcut, and this is probably one of the best shortcuts out there. All right, so save everything up in here. Okay, look right here, notes. And so Joe Kazor, one of our brokers, says, wow, notes, look at that. I didn't even know I could do that. He saves everything, right? So you click on notes up here at the top, you click on the new note, and then what does it do? It pops down a window that dates and time stamps the new note. You type in your new note. Right. And so, what do you do from there? Well, you can either trash it, which I'm going to do in a minute, or you can save it, or you can save and notify. But once you save it, you can't delete it. Okay, so let's try that. I'm going to hit the save button. you can see a previous one I did delete because I hadn't saved it yet. And so now I'm going to go back over to my transaction. I'm going to let that all process. I'm going to go back to my notes again. Again, if I'm writing notes, about what was going on today in the transaction, folks, if you're doing a transaction at a time, can you focus a little bit long enough just to write these notes down? Okay. Again, a contemporaneous note. So let me see. I'm going to test myself to see I saved it. Oh, look at that. I can delete it. Okay. That's really interesting. Now here's the downside to being able to delete it. All right. Up here in history, you can't delete the history. All right. And so this is what I do a lot of times in my trial work is I say, I want to see a copy of the history of the account. And so this is where I'm going to see, sample transaction, things like that. Buyer offer template was added, all that stuff. And so I'm looking at the history. But for your purposes, hit the notes section, type things in, put it in there, and then you're good to go. Okay. So I want everything in here. The Department of Real Estate has said you should keep everything in one place, right? Remember that broker with 5 different email addresses? Keep everything in one place. You're getting paid a lot of money to do a real estate transaction, right? And you need to, use your time when you're doing this to effectively save your notes, save all of your email correspondence. And again, down here, my conversation log, this is where I'm going to add a document. And so I'll click on the add a document field and I'll pull up the document that I want to add in there. And then I'll hit the OK button and we'll be good to go. All right. But, essentially I'm saving, all my email conversations. I PDF them and I save them up there. Is everybody good with that so far? Are we okay? We're going to come back to this in a minute. I'm going to show you some other stuff, but that's kind of the big part about it. So when should you save it? Obviously, DRE requires it. Give it all to the broker within 72 hours. Some of that's redundant there. Sorry about that. Because the broker has 5 days to review and disapprove. So for example, you take a listing, you've got 3 days to get all that information to your broker. Okay. In Linda's office, it's 1 day, 24 hours. Okay. But why does the DRE set a 72-hour requirement, which really should say 3 days? We've changed all of our language at CAR to days, not hours. But why do they require it within 3 days? Because they give the broker 5 days to decide whether they want the listing or not. All right. And so the broker can literally, it says right in the listing agreement, the broker can decline to take the listing even after the seller has signed it and their agent has signed it. And there could be reasons for that, whatever those are. But again, the DRE gives the broker 5 days to cancel, but the real estate agent has to get it to the broker. So remember that file that people come into my office, it closes tomorrow, on Friday. And then I'm like, well, I don't have any time to review this. And DRE's requirement was you get it to me within 3 days, and you didn't do that. And so we're going to have some DRE issues in addition to the fact that we have issues with, the file is not ready for closing as far as the broker's concerned. So again, your written agreement may require less time. So let's talk about some of the technical stuff, and I'll try to go through this pretty quickly, but it's some interesting stuff. So the broker shall retain a copy of such documents by causing a paper copy of the document to be made. And why is that? Because the Department of Real Estate doesn't want you emailing these mega files over to them. You have to have a copy of the document, right? Again, anything material to the transaction, and you have to produce it in paper form. They're not going to take the email unless it's 1 or 2, or as I said when I talked to the department the other day about a class I'm teaching, they said under 14 pages, go ahead and send it, but we're not printing anything beyond that. And so when the DRE asks you for stuff, it rarely is less than 14 pages. So causing a paper copy of the document to be made, or by using electronic image storage media pursuant to 2729. Okay, and so 2729, let's take a look at 2729. And again, you can read this if you want to. I would think that it's probably some among the most boring stuff that you can read. Where is this here? This is regulations of the commissioner. So I pulled up the entire regulations of the real estate commissioner, and then let me see if I've got my bookmark in here. Well, anyway, 2729. So you see here, this is the entire thing. It is only 124 pages long, right? I'm preparing to take the West Virginia broker's exam, and theirs is 108 pages long, but text on the pages is 92 pages. I'm just shocked at the difference between the two. So anyway, as I fly down through here, again, looking for 2729, and again, most of this presentation today came directly from the DRE, from the commissioner's regulations. Okay, so broker salesman relationship agreements, performing license activities through a partnership, broker salesman operating from a branch office. And then here's 2729, which is my record retention, right? There's a lot of stuff in here, but I'm going to go through this with you. If you want to copy this, I'll send this to you. Is everybody okay with that? If you want a copy, I will absolutely send it to you. So that's 2729. So again, write only. They don't want it to have an erasable feature to it. All right. Now, by the way, that's a little bit different than what you can do in the Zip Forms product. But again, remember that history thing? If you delete it, we're going to find it, right? So, I'm one of those guys that gets hired to find stuff. So Uniform Electronic Transactions Act, and you don't need to know all this stuff, but the broker may retain copies of such documents at a location other than the broker's place of business. And so what does that mean? That means like when I was with the Rock people, we had a warehouse, and the warehouse was full of boxes, and God knows they did a great job of indexing all these files so that it wasn't that difficult for the keeper of the record to find a specific property. And what we would do is we'd keep all the disclosures for sure. And then when we would list the property again, maybe years later, we would pull those out of those archives and we would provide those disclosures to the buyer. I have done many of those myself, where I have files from properties that I have sold multiple times, and I'm going to keep those disclosures and I'm going to provide them at the time of a resale of that same property. Okay, everybody good with that? But where's the other place I could keep it? Off-site in the cloud, right? So you remember from, and we'll talk about it in a minute, but the DRE has said Google Drive, Dropbox, things like that are okay as long as your file has not been compromised. If you're aware that somebody has access to your file and you continue to use it, that's going to be a citable offense, okay? And that's a quote. All right, so cloud, offsite, whatever. Do you need to keep it in the office? The answer is probably not. But we'll talk about what you do in the office in a minute, about what those filing cabinets should look like. So again, regulations of the commissioner 2729, you may use electronic image storage media to retain and store copies of all listings, deposit receipts, canceled checks, trust records, and other documents executed by the broker or obtained by the broker in connection with any transaction for which the broker's license is required. That pretty much buttons it up. Provided the following are met, it has to be a worm, write once, read many, non-erasable, very important, does not allow changes to the stored document or record, is made or preserved as part of it in the regular course of business. So it's the ordinary course of business rule. It's a legal principle. All right. So these are the things that you should be keeping a record of. The original record was copied, was made or prepared by the broker, or the broker's retained staff or employees. At or near time, the condition, remember my contemporaneous note, the custodian of the record, the one that is responsible, and it could very well be the broker, is able to identify the stored document or record, the mode of its preparation, the mode of storing it on the electronic image storage, and again, ready access to a desired document or record. As I said earlier, we had a great indexing system for our records with the Rock people. It was all in a warehouse. We had everything in a warehouse, but we could get to it pretty quick. The people that had authority over that could do that pretty quick. Appropriate quality control, making sure it's not subject to people stealing it or vandalizing it. And again, to ensure the quality of image documents or records and the date ordered arrangement, right? We need to have that in there as well, to assure a consistent logical flow of paperwork to preclude unnecessary search time. Why? Because they don't want to be sitting around waiting for it. Now, interestingly enough, as our industry has changed and a lot of people are operating out of their homes and things like that, the Department of Real Estate, I was talking to a broker yesterday about this, Department of Real Estate will come by the office and just, for educational purposes, they'll drop off educational materials and things like that. God love them. I mean, especially because now you're getting really current stuff. Okay. But in a lot of situations, the broker's not there or whatever. And so they really don't have anybody they want to talk with. That's kind of an important thing. Hannah, you have a question? Put it in the Q&A. Okay, hon? So because of the fact that the brokers, some of the brokers, remember the DRE is really clear. You may not operate out of a PO box, okay, because they want service of process to be able to be affected, okay. So, but they do want to be able to get access to your records. So if they stop by or if they send you the letter, either way, you need to be prepared to come up with this stuff pretty quickly and probably in print form. Okay, everybody okay with that? Hannah, I think you had your hand up. You took it back down again. Okay. Are you just saying hi? Maybe you're saying hi. Hi. Thank you. Thank you. I always get a kick out of that, but thank you. Okay. Records copies stored under this section shall be retained for 3 years. Is anybody not clear about the 3-year requirement? Right. And remember, because part of the reason behind that is that the statute of limitations in most situations is going to be 3 years. And I'm going to talk to you in a second about some exceptions to that. All right. So, and again, that's section 10148 of the what's called the B&P code. So I showed you the commissioner's regulation. Let's take the B&B code. Here it is. And so this is where we go down right here. I did it in such a way that you can see here's 10148. Does anybody really want to read all this stuff? That's why I'm doing what I'm doing right now. 2 hours of me or a lifetime reading this stuff, and it changes regularly. So interestingly enough, the commissioner shall charge a real estate broker for the cost of any audit. So in other words, if the commissioner's office audits your file, or investigates you, and in fact, one of the decisions I read this morning, they charged them for the cost of the investigation. That's just the way California law works. And if you don't like it, change the law. But it's the way that it is. You're actually going to have to pay for them to investigate you. Okay. All right. So, and if you fail to pay for the cost of an audit, et cetera, et cetera, et cetera. Okay. So again, I have a tremendous amount of respect for the Department of Real Estate, but they're following the rules. So, it's like, those are the rules. And if you don't like the rules, let's pass a law that gets rid of the rules. But that's 10148 in its simplest form. I wanted you to see that we had that. And fortunately, I'm getting really good about making sure that I'm, popping up that second screen for y'all. I've got another computer over here where I can see what you can see. So, okay, so that's what that is. And then a broker will maintain at the broker's office a means of viewing copies of documents or records stored pursuant to the section. Record retention, again, a little bit, I'm speeding up a little bit here. Who obtains documents with any transaction for which license is required. When such document contains electronic signature, this is a different rule. The Uniform Electronic Transactions Act shall retain a copy of such documents, including the electronic signature. Do not throw those away. Interestingly enough, during the COVID crisis, whatever it was, that we were doing the PVOH forms, and we were doing the PED forms, if you all remember, the property entry forms, and they were being signed by our clients prior to giving entry to the property. And it was a law in California passed by the current governor, and so we were required to have it. And so I put it in my my newsletter that the DRE is going in and looking for those PED forms. They're contacting brokerage firms and they're saying, we want to see a copy of those PED. But a lot of times the agent didn't keep the PED form. Well, you need to keep those forms. Remember what I said earlier? Anything signed by a principal, anything signed by a party, anything signed during that transaction, you need to keep a copy of it. I don't think it's that onerous a task. Okay. All right. So the broker shall retain copies of such documents by, again, and some of this is redundant, I apologize, at a location other than the place of business. And again, because they have a couple of different rules that are stated in different manner. So after notice by the commissioner or his designated representative during regular business hours, they can't come by on Saturday morning unless that's part of your regular business hours. Broker shall provide at the broker's expense a paper copy of any document or record requested by the Bureau. Normally, they don't ask you for a single document. They ask you for your file. Okay, so, and again, this was my favorite. This is where we kind of really close that loop. Nothing in the section shall be construed to permit the broker to avoid compliance with 10148. So what we're looking at here was the commissioner's regulations, but it says, nothing inconsistent with what 10148 B&P code says. Okay, everybody all right? Okay, B&P code, and I just showed that to you a second ago, so I won't pull it up again. And that one says in a different manner, shall retain for 3 years copies of all listings, deposit receipts. Remember, sold or not, keep a copy of anything signed by a party, deposit receipts, canceled checks, trust records, other documents executed by him or her, obtained by him or her in connection with any transactions for which a real estate broker's license is required. And so remember, the law says that you need a real estate license in order to do transactions for others. If you can buy and sell your own home until the cows come home, but if you are affiliated with a brokerage as a sales associate with a brokerage, then you are going to be subject to the DRE's regulation on that issue. Okay, so all right. Department may suspend or revoke the license of any broker, salesperson, or corporation, even a corporation licensed as a real estate broker, if those people knowingly destroy. Remember what I said earlier? Do not delete these things. I know they get it. I know we had recent, presidential candidate that did, but this is against the law, and so destroys, alters, conceals, mutilates, falsifies any of this stuff in connection with an audit or examination of a real estate licensee by the commissioner. Okay. And so remember that the file belongs to your broker. I need to get past some of that stuff, but remember the file belongs to your broker. So we used to call them a shadow file or a ghost file. And that was where, we would take a look at the broker's file, it'd be like this. We take a look at the agent's file, it'd be like that. And we was like, well, how come there's such a huge difference? Well, because the agent was running around carrying everything around with them in their car and doing stuff like some of that stuff needed to be in the broker's office. So for example, that earnest money check, remember the old EMD thing? That earnest money check needed to be in the broker's office and right away. And so I actually was management with the red people, and they actually cut a hole in the door because I walked into the kitchen one day and here's this trust book and it was full. There were hot checks in there, right? And so fortunately, I changed some of the policy there, and then they cut a hole in the door of the office of the person that was handling all the books. You put that check in there and you can't touch it again. And that's how it should be. And it's a DRE requirement. Okay. So, my hat is off to them for doing that. So no shadow or ghost files. Your broker's file needs to be bigger than your file. All right. Remember that Privacy Act issue? If somebody gives me a social security number, I'm getting out of my hands right away. I tell agents all the time, do not send me a proof of funds that includes the account numbers. We did a transaction just recently where the buyer called the bank, and the bank wrote a letter rather than sending copies of the accounting. And if you're doing business with people from other countries, that's the way they do it. Somebody's from Nicaragua, they're gonna send, the bank manager's gonna send you a letter saying they got plenty of money in there or whatever. So, but some of this stuff you got to be careful. Those account numbers and stuff can create real serious problems for us. All right. So where are you going to keep it? I think you should keep it in zip forms. But I want you to remember a couple of rules. One of them, remember what I said earlier, they're automatically going to shred the files once they hit the 5-year mark. Okay. So once they hit that 5-year mark, they're going to shred it. So how do you prevent that from happening? Well, let me show you. I'll show you. It's a neat trick. Okay. So I'm going to take you back into the file. And so what did I do in here? I went in, I grabbed the file, and I did something really simple, like I want to move. So acting against the advice of the broker, I'm going to go up here. I'm going to move this over into the BRBC file. Boom. And that just started the clock, the 5-year clock again. That is a way to do it. I think it's going to kind of defeat the purpose. You want to keep going back in and doing stuff like that? Probably not. Once again, I'm going to go up here to the top. I'm going to click my export to file or export to archive. And then I'm going to save it in the cloud or someplace, where I've got 3 terabytes of space on my Google One account. I think I've got 2 terabytes of space in my Dropbox account. Because my broker saves everything. I mean, pictures, everything. So it's like, okay, I'm just going to have massive storage files because it's too much for me to figure out how to get rid of some of that stuff. Okay, so everybody good with that? All right. So that being said, let me go back to, we'll probably get done a little bit early here today, I hope. So 5 years. Now, by the way, if you are in the file and let's say that you have something in zip forms and nothing's been signed. So for example, this file right here, there's nothing in here that's been signed by anybody because it's just a sample transaction. They're going to delete this within 18 months because it doesn't have anything signed. Okay, because remember, the signature creates the zip vault account. All right, we start saving it that way. That's what creates a zip vault account. So they don't see a signature in here, so they're going to delete it in 18 months. They're going to shred it. I mean, it is gone for good. All right. So my little act of going in there and moving that document is going to start the time period again for another 18 months, right? Unless I use this transaction to create an escrow or something, whatever, that I'll start the clock ticking again. Once they sign something, now the clock is 5 years, not 18 months. Everybody okay with that? All right. Okay. That being said, untouched files, as I said a second ago, an untouched file, which means no zip vault account, no signatures, are going to be, that's curious, will be deleted at the 18-month mark. And I said that already a second ago. Broker version of zip forms, if your broker is using the broker version, and I was teaching it for quite a long period of time, but they kept charging me to teach it, so I stopped teaching it. But it's a great way for the broker to supervise what their agents are doing. And so the broker version is really good. The broker can create a template for you, and then you just log into your account under the broker's version, and then you use the broker's template. The DRE, as I said earlier, says it's okay to use that account as long as the file's not compromised. For the new RPA, the Dropbox, the Google Drive, those kinds of things are all okay, but with the same caveat as we just saw from the DRE a second ago. Could it be in a locked filing cabinet in the broker's office? And the answer is yes. Most brokerages are doing so many transactions, and one filing cabinet is not going to be enough. But again, these are important things, locked. So I had an audit that I was asked to attend where the broker, when I went in the day before, because they always call me the day before. When are they coming? They're coming tomorrow at 10 o'clock. Oh, great. So I go in there and I see the filing cabinet in the office, and I see the keys to the filing cabinet dangling out of the lock. Right. And so I made a comment to the broker. I said, you want to be really clear not to lock that filing cabinet when they get here, because they want to know it's locked, and have the keys in your pocket or someplace where they're not readily accessible, because otherwise it's not locked filing cabinet in your office. Technically speaking, does it have to be locked when your office is also locked? Remember, when they start looking at like controlled escrow companies and things, controlled business, things like that, they're looking for all this stuff. The escrow company, the only way in and out can be, it has to be locked away from everybody else's hands. Not even the agent can come into that office. Okay, so it's very important. The keyword there, locked filing cabinet in the broker's office. Okay, all right, not in your office, in the broker's office. Okay, all right. How long? Again, 3 years from close of escrow, which is legally it's transfer of title from seller to the buyer. 3 years from transaction documents, if not closed. So again, if somebody signs something, you got to hang on to that for 3 years. But anything before that, you don't necessarily have to hang on to it. I'm going to tell you, I probably would, but again, check with your broker and your broker's policy on that. Records copied and stored shall be retained for 3 years. I just cited the civil or the BMP code again. Statute of limitations is generally 3 to 4 years. Depends on the circumstances. What's the statute of limitations for fraud? There is 3 years from the date of discovery. So essentially no statute of limitations. Think about it for a second. I had a lawsuit I was asked to testify in where the buyer was suing the seller on a transaction that had closed 7 years earlier, and clearly they were beyond the statute of limitations, but they alleged fraud. And so if you allege fraud, at least you get your day in court. In this case, the judge found that there was no fraud, and so I was surprised the attorney kept their license. But essentially 3 years from date of discovery, so they don't discover the fraud until 7 years from now. Now they got 3 years to file the lawsuit. So do you want that to be you? What I would recommend is if you're saving your file, you at least have those disclosures, et cetera, to protect yourself, except when, again, required to file the lawsuit. So probably best to save, and again, export to archive. I am going to get done early today. Export to archive, as I showed you a minute ago, all disclosures. And so if I take you back to there just real quick, and I hit on my export to archive, Here I have the ability, and I'm going to tell you, it's an interesting quirk in the program, but when I contacted Lone Wolf about this, they said, don't touch anything. But my comment was, I might not want all this stuff. So here's what you definitely want: the content. Are you going to keep all of these things? Maybe not. Maybe you go through here and you look for things that are signed by parties. Maybe that's all you keep. But if you didn't have a disclosure signed, you're probably going to have other problems anyway. So you would sign whatever was in here that, or you would keep whatever was in here that the client signed. So are you really worried about filing space? Probably not, right? I mean, I'm doing over 100 transactions a year. So, I probably have more reason to keep a large storage facility for things than most. But, and again, I do work, I help other brokers as well. So best to put all the disclosures away forever, hang on to those. You just never know when that litigation is going to come. So how long? Again, best practices. Let's take a look at an example. Again, zip forms is probably your best bet, and I've shown you this a couple of times already. It is the standard of practice in California, in the state of California. So again, a little bit of a repeat, I apologize. Automatically shreds everything that hasn't been touched within 5 years. And if there's no completion, that's going to, no zip fault account. So Wayne Bell, goodness gracious, I'm really going to get you done early. This is a first. Wayne Bell, who was our commissioner previous to McCauley, who's actually a great guy. I got to correspond with him on a couple of occasions now, and some of them in person at the CAR meetings. If you ever get a chance to go, I think Anaheim's coming up in September. I think it's the 19th or the 20th of September. And so the commissioner has a forum at that point where they get up and they answer questions about retention and violations and what are the numbers looking like in California and stuff like that. It's a great opportunity to really meet with the commissioner, and so I think it's a good thing to have. It's only about an hour long, hour and a half maybe, but certainly an educational event. I went to every single one of those, except that they were conflicting with other things that I was doing in the last dozen years or so. But when I was chair of risk management last year for the California Association of Realtors, they came in and the commissioner's office did their presentation right after mine, in the same room essentially, and I had an opportunity to go up and introduce myself to everybody. And interestingly enough, they remembered me from a webinar I did for them on the RPA and some of the things that we're seeing in the RPA that have created some issues. So anyway, Wayne Bell, who I just, he was an attorney. He was a licensed barred attorney, and he was probably one of the most prolific writers. He was also the head of enforcement for the Department of Real Estate for 20 years before he became the commissioner. So he gave us some wise advice, and he says, my conclusion is that professionalism in performing real estate license services requires licensees to have the knowledge, skills, and abilities gained through education and/or practice and experience, and thoroughness and preparation, including organization and diligence, right, to well and ethically represent their clients. And so, so that's a quote, right? So up here, where is he? The movement toward professionalism. And again, I'll send you all this stuff. He wrote this, and this was on starting on page 4. So right here, my conclusion, it wouldn't let me highlight any of this, but my conclusion, and there was his conclusion. And so I think this makes a great article. And by the way, you should be getting these articles from the Department of Real Estate. And if you're not getting them, let me show you. This is back when it was Cal BRE. If you're not getting them, let me show you how to get these, because these are really, really, really good documents to have. So I'm going to go to dre.ca.gov. And so here's the, whoops, you can't see that. Okay, hang on. Good, I caught myself. There it is, dre.ca.gov. There you go. Okay, down here towards about a third of the way or halfway down the page, you see this orange button. If you hover over it, it says RSS. So that's called an RSS link. And if anybody know what RSS stands for? It stands for really simple syndication. Click on the link. and it pops up this here. I have subscribed to everything because they're telling us what they're going after. They're telling us what they're doing. And so please put that in there. I get, they don't send them out that frequently. I mean, what, quarterly? So, you know, I like getting them. I want to know what it is that's going on in my real estate world. And so I would put your email address in both of these, and they're not putting you on a list. It's not like they're watching you or anything. They're not, trust me, they got enough people. But one of the reasons they did this was because, you know, back in the day when I got my license, they would send us a bulletin in the mail. You know, at that time they had less than 100,000 people, way less than 100,000. In fact, frankly, I think it was about 70,000 licensees in the state of California. So they would print the bulletin and they would send it to us, right? But, you know, when they would print it and send it to us, they would, you know, what did we ever do with it? Well, let's take a look. I want to show you something here. And this is why, here's the real estate bulletin. Did everybody see what I did? I went up here to the publications at the top. I clicked on real estate bulletin. And it popped up the current one, the spring of 2023. It's going to take me to, okay, good. We'll save this in our file. I'm going to pull this up, and there's our current commissioner. That worked out well. So there's our current commissioner, and nice man. I like him, Macaulay. And so this is what they do. He writes about all this stuff, home ownership stuff, that changes to pre-licensed education course requirements. Okay, those kinds of things. So for people like me who teaches these classes, they become very, very important. But you know, you should look at what it is that the requirements are for the continuing education. So here's all this information. Download for free. The new real estate law book is available for free. Did you download it? I think you should download it. I think it's really, really important. Okay. All right. And then I go down through here, and here's more of the commissioner's update. Let me fast forward this a little bit. There's the commissioner's tweet address. And then what do you know? A quiz on California real estate law. Okay, each of the following statements about advertising, true or false. Advertising must always include the broker's number. And so then they're going to give you the answers later. So these are good, you know, little things. Living in a common interest development. All right. So these are kind of some of the stuff that you really should probably know about. Let me see. Helping your client understand an architect's role. Again, there's a lot of material in here, even with what we're doing. Broker supervision requirements under California real estate law. So you know you're going to get the current stuff, and this is going to be Reg 2725. Remember, we already talked about 2079. Okay, so again, all this is really good to have. But in the old days, they would send this to us. They would print it to and send it to us. But the only thing, unfortunately, that that we were usually, oh, you can't see that. Darn it, where'd it go? Sorry about that. Where did it go? Okay, now you can. That's funny. You can see it, but I can't see it. So. Crap. Back over here. Linda. You're seeing that on your screen, but that's not what I'm looking at over here. So how do I get out of that? Go back into this and there. Okay, so now I can see it. So, but what most people were doing was they were taking the notes from the department and confirming letter. So I'm in the wrong place again. This is not it. So it's not allowing me to switch. That's not good. I do want to show you what I'm talking. Okay, here we go. So I'm going to go up here. I'm going to go to the DRE website, and this is what most people were looking at when they were up on the DRE website. Is they go up here and they would look for disciplinary actions. This is what was coming out. It was in the middle of that publication. So you can see that. Yes. So view the list of entities that have been served with desist and refrain orders. You know, and so here's the whole list of people that got nailed, and it's quite a few. Right? But then there was also the even more inclusive list was summary of enforcement actions down here. And so you can actually pull these up now. Most recent report available from 2023. And this was all we ever did. This is all we ever looked at. And so the commissioner's office said, why are we still sending these things out? I mean, I hate to scroll through. I've gone through these things, by the way, teaching classes and then seeing people that I knew, who had their licenses suspended or revoked or whatever. And so the department said, oh, we don't want to do that anymore. We don't want to keep sending those things out because they're just getting pitched. So that's why they went to the alternative, which was to do them on their, put them on their website. Okay. Which God knows if I'll be able to get back to that. Is this it here? Yes, this is it here. So this is the commissioner's website. And then again, back to the home button. And then down here mid-page, there's my RSS link. So I would recommend that you sign up for that because I think that's going to be really helpful for you in what we're going to be doing. So let's go back to my PowerPoint. We're literally almost done. I'm surprised that we're done so quickly, but I showed you the zip forms product. I showed you how to do all that. I showed you how to export things to archives so that you have your records. So let's go ahead and wrap it up here. PowerPoint and from the current slide. Whoop. No, that's not the current slide. All right. So down. This is a lot of work. Okay. So I'm just going as fast as I can. I'm sorry. So there's Wayne Bell's advice. I do hope that all of this helps. And that's why I wanted to show you that. I do hope that all of this helps. A potentially difficult situation, whatever it is, again, make sure you're checking with your broker. If you see something that could result in litigation or something could make somebody unhappy. Unhappy people tend to talk to lawyers, and that can get really expensive because once the lawyers get a hold of it, they tend to latch on. So it's got fairly easy solutions. Keep good records, keep good notes. The truth will set you free. When we consistently maintain our professional standard, we're going to succeed, hopefully, in any kind of litigation that we get involved in. So thank you for joining us for our discussion. Are there any other questions? Maintaining records and reducing risk. Anybody have any questions? I'm getting out of here a half an hour earlier. I'm just worried that I haven't shown you everything that I was planning on showing you. Let me pull, let's see here. Oh, the broker compliance evaluation manual. So most of the rest of it's already shown you everything. So here we go. Broker compliance evaluation manual, which is put out by the Department of Real Estate. And so in scrolling through this just really quick, I'm still going to let you out early. So from summer of 2019 is the last time they wrote it, which is actually when we wrote our office policy manual. And so again, written to assist the real estate broker in residential sales to be compliant. And so it asks a series of questions, as you can see. And again, if you want copies of all this, I am more than happy to send this to you. Just send me an email and I am happy to make that go forward for you. So a lot of really good stuff in there. So without going through the whole thing, I think that's pretty much speaks for itself. If you'd like to view any of our previous webinars, and we do have, I've been loading them back up onto the YouTube website. So we have a new YouTube website. Get your QR code reader ready, and you all have probably one of those on your phone, right? And so get your QR code ready. I just learned how to create QR codes about a month ago now, so I'm very proud of it. If you click on that, it will take you to our YouTube website that has all of our the videos that I've been loading up there. And you could also go to @Burke Real Estate Consultants Inc. No.com. Just that should take you straight there. We also have the bit.ly link. So case is important here. So bit.ly/real-estate-ed. Please, when you go there, remember to like and subscribe. That would really do me a tremendous favor, just to know that you appreciate it. All that subscribe does, by the way, is notify you when I update a new one, when I put a new one in there, okay? So please do that if you wouldn't mind. You got other stuff you want us to talk about? Email to education@sdar.com. You can always send me an email, and I'm going to probably copy them in the response. I do have weekly email updates that I send out that have, in fact, an interesting diatribe about the PED forms I was talking about earlier today. but I don't put people on the newsletter unless you ask to be put on it. So send me an email, say, please sign me up for your newsletter, and I'll be happy to do it. And if you don't want to be on the newsletter, don't send me an email saying put me on the newsletter. And if you want off the newsletter, which I doubt, I've had probably 3 unsubscribes in the last 5 or 6 years. But just send me an email. I'll take you off of there. There's no harm, no foul. But again, on the newsletters included the links to my classes so that you can just click on the link and it will take you there to sign up. You bypass the message that says classes sold out, so it kind of makes it a little bit more streamlined. So again, my hat is off. Thank you to the people at the Department of Education at SDAR for making all this possible. So any other questions anybody wants to address at this point? If not, I'm going to bid you farewell. I'll be back at 2 o'clock. We'll be doing all about disclosures, and hopefully I'll get to see you then. So thank you all for being here today, and I wish you the very best. Take care for now. Bye-bye.